going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. Hope you guys are all having a great long weekend. Yeah, we're almost halfway through it. Today, it feels like Sunday. It does. It feels like Sunday. But it is not. It is Friday. We still have 2 more days. Usually I'm okay for holidays because I have a lot of court to go through all my vaults. And I have been doing that, but I've been missing live court. I really am. There's a few courts that are live on holidays and weekends. They're just not the same. You know, it's not Judge Simpson, it's not Judge Middleton, but we're making it through. I actually miss live court. All right, I'm rambling. I've got 2 cases for you guys tonight. The first one is illegal towing. And it's interesting. It's funny at some points. It's just all around kind of weird. And I don't remember what the second one is. I already forgot. So we'll see what it is. Oh, the second one's Judge Webster. Okay. All right. I'm rambling now. Hopefully you guys enjoy this. Before I hit that play button, you know what to do. Hit the like, subscribe, do your jump kickback flips. Let's go.
This motion was filed on both Mr. and Mrs. Flores' cases. I represent Mr. Flores. Ms. Hennigan represents Mrs. Flores. I don't see Ms. Hennigan here. I don't know if she was. Oh, she's there on Zoom. I didn't know. I was intending to argue first, and then if Ms. Hennigan wanted to, supplement after that, if she's okay with that, that was my intention. Is that okay, Ms. Hennigan, for me to argue first?
Absolutely fine with me.
All right, so this, we are on the record in 2 files, file 24-21845-FH and 24-21886-FH. People versus Raymond Flores in the 845 matter and People versus Emily Flores in the 886 matter. We're here today for a hearing on a motion to quash the information and dismiss. We are proceeding today partially in person and partially by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayanetto for the people.
Alex Bayanetto for the people.
And Mr. Murphy.
Matthew Murphy, appearing on behalf of Raymond Flores.
And Ms. Hennigan.
Tamiris Hennigan on behalf of Emily Flores.
All right, Mr. Murphy, if you'd like to proceed.
All right, we haven't gotten into it anymore. We haven't got into it yet, so I can pause it. VF, thank you so much for becoming a new member. I appreciate it. Welcome to the family. Let's see, Members Monday. It's still Friday. I almost said Members Monday is tomorrow. It's not Sunday. Calm down, Colin. All right, VF, thank you so much.
With oral arguments, you can do that now.
Yes, Your Honor. There wasn't much I was going to add. Your Honor has the briefing that we filed on this matter. I just wanted to express again, reiterate that as the courts have expressed in their opinions in the cases that I've cited in our brief, the burden is on the people in this matter to show that the police acted in accordance with procedures to avoid the, I guess you would say arbitrary impoundment of vehicles. And that was clear from the case that we had cited. Now, in this matter, we provided the court with body cam footage. I do apologize to the court for the length of that body cam footage. I had contemplated and was going to submit just a brief portion, the first 5 minutes or so. But ultimately, we decided to submit the entirety of the body cam footage to the court. As you can see in the body cam footage, it's pretty clear. We believe in the body cam footage that the officers in this matter, they weren't acting in accordance with any cited procedures. The officer, as Your Honor could see from the body cam footage, he was allowing Mr. and Mrs. Flores to try to take the vehicle away, allowing to get a person to come. He actually had expressed that make sure the person that comes is a valid licensed driver. And that, as Your Honor, as we point out in the brief, as you can see in the body cam, that's what ultimately started the exchange that we said that it led to the arbitrary impoundment of the vehicle. the officer got upset with the reaction that Mr. Flores was intoxicated. That was understandable, or that was admitted to. So it should have been understandable that he was acting, again, not very rational. Mr. Flores had insulted the officer. That led the officer to then say, okay, well, now here's what's happening. We're going to impound the vehicle. Again, the fact that people may later on try to come up with some explanation for why the officer could do what he did, that's not the lodestar. That's not the guiding post, Your Honor. The guiding post is what the officer did at that time, what his intentions were at the time. And that's why, again, the case that we cited, they were showing how volatile this situation is. As they said, a person has a right to defend themselves against illegal police action, and that's the action of the police at the time that it occurs, not later on, not at a hearing a month or 2 months or 6 months or a year later. It's a reaction to what's occurring at the time. And that's why the body cam footage is important in this matter, because the body cam footage showed the court what the officer was doing at the time and all the actions that occurred after that. And again, we also want to point out that the policy that was cited by the prosecutor in this matter, that's not the end of everything, Your Honor. There is, obviously, there's a statute involving this, MCL 257.25D. That is the state statute that involves towing of a vehicle. Now, the policy that the prosecutor had cited here, it ultimately says that the police, it's the Adrian City Police Department's policy, and I have concern about the section because it ultimately says that it's at the discretion of the police department. And I don't think that's important with the statute, Your Honor. That's exactly against what they're trying to prevent here. That the statute says that you can't have it just where they decide to use their discretion. They have to follow per the procedures. And again, we cite here, we cited the case that show that, again, the reaction, as we're arguing, Mr. and Mrs. Flores' actions were trying to defend themselves against the illegal towing of the vehicle. And I go on to further to Mr. Flores' case. After his interaction, as you can see from the body cam footage, the police tried to say, well, now you have to leave, now you're being disorderly. And again, as we tried to express, he was doing exactly what the police were trying to tell him to do, which is he went off on the sidewalk. And then they say, well, now you're being disorderly by being intoxicated, which they knew he was intoxicated, and being intoxicated, being on the sidewalk and acting the way you're acting. Again, he was objecting to the police. I phrased it in my brief as verbal resistance. He wasn't punching, he wasn't fighting, he wasn't physically at that point, but he was saying things to stop the police from doing what they were doing. Also, I want to point out that once that moved onto the sidewalk, again, freedom of speech, as he expressed in the video, he believed he was protected by freedom of speech to express his disapproval of what the police were doing, and again, trying to stop them from illegally towing the vehicle. Now, again, the situation isn't ideal. Mr. and Mrs. Flores were intoxicated. That's again why we fall back on what the case have cited, where this is involving the person's reaction to the police at the time. And again, with them being intoxicated and the police officers not being intoxicated, there should have been some sort of de-escalation on the part of the officer, as opposed to I don't like what you're saying, let's tow the vehicle. That's why these things occur. That's why the police are trained in the matter, and they're supposed to follow the procedures. If they follow the proper procedure in this matter, again, according to the statute, I'll read this. Does the court want to provide a copy of it, or does the court need the statute that I'm referring to here?
I can look it up.
According to the statute, Your Honor, it says that if you go to 257, again, 252D2, it says, unless the vehicle is ordered to be towed under subsection 1A, D, E, or K of this statute. So let's refer to section 1A. 1A is that if the vehicle is in such a condition that the continued operation of the vehicle upon the highway will not constitute immediate hazard. That's not the case here. Let's go to section D. If there's a reasonable belief the vehicle or any part of the vehicle is stolen. I don't believe that was asserted here. Go down to section E. Section E is if the vehicle must be seized to preserve evidence. That wasn't asserted here. And section K says if the vehicle has been involved in a traffic accident. That's not the situation here. So again, the section says that unless it was one of those four, that when the owner of the vehicle becomes present, the keys must be turned over to the owner. That the vehicle must be, the towing must stop. That if it's actually on the tow truck, it must be taken off the truck, and the person must be allowed to pay it out. That's what the section says. So, from my understanding, the prosecution is trying to assert that it was being towed per the Adrian City Police policy. Again, from my understanding, that policy wouldn't dictate that they wouldn't have to follow this statute that says that once the owner, granted that Ms. Flores couldn't drive, but she had a person come, and you could see on the body cam, they came within a few minutes, and that was expressed to the officers at the time that they was going to be there immediately in a few minutes, and they were there, which actually the people had cited as causing the bigger issue. 5 people arrived to take the vehicle away. According to the statute, what we're saying is that at that point, anything further, before that, okay, but at that point, it should have been turned over to Ms. Flores to then be turned over to them to drive away from that property, Your Honor. So again, I went longer than I expected to. I do apologize for that, but we do believe that if you get looking at the case law that we cited in our brief, looking at the body cam footage, and again, remembering the burden's on the people, that the police have to follow proper procedures here to the T as much as possible to avoid arbitrary and discriminatory behavior on their part. And again, they should not be allowed to just decide it's in our discretion to tow a vehicle out. So with that, Your Honor, we would ask the court to grant the motion to quash. We would ask the court to dismiss the case based upon that. We would also ask the court in the alternative that if there was further necessity for it, in lieu of not completely dismissing our motion, to perhaps grant a remand on a district court for a examination. I guess if that was another option the court considered doing. Of course, I believe based upon the body cam footage provided that there will be no further evidence presented at the examination that would further help the situation or further explain or have any other further facts. So I would ask the court again to grant the motion to dismiss. Thank you, Your Honor.
Did the defense waive the?
All right. I wanted to let it play throughout his entire argument. So his client, there's 2 of them. I think husband and wife, boyfriend, girlfriend. I don't remember the relationship, but one of them got a DUI. I think the guy might have got a DUI. He was driving. She was in the passenger seat. He was being an asshole to the police. The police towed his car. As per usual. Usually when you get a DUI, they tow your car. He's saying it's illegal. He's about to drop the unconstitutional part after the state's about to talk, and then he's going to have his chance at a rebuttal. And it's funny. I don't understand what he's fighting for. I mean, he's fighting for his clients, but calm down, man. Your client's got a DUI. And yeah, you'll see, guys. You'll see. Before I click that play button, Mary, thank you so much for the super sticker. I appreciate it. Thank you. That is awesome. Isn't that special? They do not show the body cam. They're not really fighting the DUI here. They're fighting the illegal tow. So he's saying he wants. He's trying to dismiss the case, but he's spending all the time on the tow when he's talking about it. They're not arguing that the guy was drunk. I think he actually even admitted it a couple times. So yeah, I don't know what he's trying to dismiss. I missed that. Heather. Oh yeah, but no body cams. Sorry, we don't get to see him.
Yes, we did, Your Honor. We waived the prelim, but things didn't go the way we were expecting.
Ms. Hennigan.
Thank you, Your Honor. Just very briefly, I would concur with everything that co-counsel has stated.
Oh, real quick, I forgot to mention this. Because there's 2 defendants, they each have their own attorney. So this is the other attorney, defense attorney.
Here this morning, and I would just add that with specific regard to my client, Emily Flores. Emily Flores is the actual owner of the vehicle, and she was not engaging in any inappropriate activity with the police. She was trying to make positive decisions that night. She had a sober person driving the vehicle, even though she and her husband had been drinking. The vehicle was pulled over, and the driver cooperated in going into custody. And Ms. Flores asked the officers if someone could come and get the vehicle. She immediately got on the phone with her children, adult that were licensed drivers, and asked them to come to where they were to pick up the vehicle. And the children did just that. They got en route to come there. It was during that time that Mr. Flores had altercation with the officer, verbal altercations with the officer that has been described to you here today. But Ms. Flores was not involved in that. And in fact, while she was loud and boisterous because of being under the influence of alcohol, her comments were directed at her husband and telling him to shut up and cooperate with the officers. So at no time was she indicating that the officers were doing anything wrong, up until the point that her family did arrive to pick up the vehicle. And Mr. Flores at that time had already been was being taken over to the police car due to his altercations with the officers. At that time is the only time that Ms. Flores got in the way of the officers, and her only concern was that she did not want her car to be towed. She was indicating to the officers that they could not tow her car because she had someone there to pick it up, and that they had told her someone could come and pick it up. She stood in front of, well, I should say on the side of the vehicle, and that was in an effort to prevent the officers from taking her vehicle, not to try to be resistant or obstructing, but because they were illegally towing or attempting to tow the vehicle, even though she had licensed drivers present, and it was actually the licensed drivers who helped to calm her down and move her out of the way at that time, even though everyone there, all of the...
Absolutely, Mo. It would absolutely be officer's discretion to tow the car and even charge her. It sounds like she got charged with some sort of disorderly, maybe drunk and disorderly. I'm not exactly sure.
People involved felt that the officers could not legally tow the vehicle, but they did try to help Ms. Flores get out of the way. So we would absolutely agree that this was not an appropriate tow per the statute, and that none of the situations that would require a mandatory towing occurred. And I would just stand on the statement that my client owned the vehicle and as owner of the vehicle was not doing anything inappropriate that would cause the officers to tow her vehicle. Thank you.
So yeah, she called a couple people that were sober to come pick the car up. It's still the officer's discretion. They don't have to give the keys to a sober person that shows up. They can. It sounds like these two were being jerks, though. I mean, I'm sure if they were nicer, the car wouldn't have got towed. I mean, that's what it sounds like to me. The body cam footage would clear this up. They're not playing it. Mayor, thank you so much for your 8 months. That is awesome. Thank you so much, Mayor. Good to see you, bud. And then Sly coming in with 5 gifted memberships. Thank you so much, Sly. And welcome to the 5 new members. Thank you, Sly. That is awesome. All right. Let's keep going. We haven't even heard from the prosecutor yet.
All right, give me just 1 second.
Yeah, sure. Need a second to get set up anyway.
Isn't that special? I actually turned my heat on. I've been holding out, turning my heat on. This is the second time this year I've had to do it. When it dropped to like -5, like 2 weeks ago, I turned it on as well.
The statute, MCL 257.252D.
Mayor, thank you. Anytime, my friend. Anytime. Anytime you're in the area, or even if you're not, you can always swing by. I like having you. The stream likes having you. I have fun. I know you have fun. You eat like a king when you're here. I'm not sure what this no sound is. Is he looking up the law that was just cited? You can't even hear the background noise. This is a little creepy for me. I don't like this kind of silence. Silence. Hey, I'm half deaf. I live in silence. Doesn't mean I like it. Playing Wordle. What's up, MB? All right, if this goes on for longer than 10 more seconds, I'm going to fast forward a little bit. All right, let's see. Oh, wow.
Private driveway.
Okay. All right.
All right, go ahead, Mr. Bennett.
Thank you, Your Honor. There's a lot to unpack based on the arguments that have been made this morning. I will start first with the argument Mr. Murphy made regarding MCL 257.252D. Your Honor, I don't think it is in dispute the fact that the driver of the vehicle, Mr. Sargent, when ordered to by police, pulled into a private driveway, not owned, that property not being owned by either Mr. or Mrs. Flores. That vehicle pulled into the driveway behind vehicles that were already parked in the driveway. That can be seen on the body cam footage. Again, I don't believe that that fact is in dispute today. Given that scenario, that situation, Your Honor, I think the court first has to determine whether or not a vehicle could be towed. 257.252D1G provides that authority to the police. Specifically, it says a police or governmental agency designated by the police agency may provide for the immediate removal of a vehicle from public or private property to a place of safekeeping at the expense of the last titled owner of the vehicle in any of the following circumstances. Specifically, subsection G states, if the vehicle is hampering the use of private property by the owner or person in charge of that property, or is parked in a manner that impedes the movement of another vehicle. Given the fact that Mr. Sargent pulled into a private driveway behind another vehicle, this situation falls under just that. So the police had the at least statutory authority to tow the vehicle in that instance. Now, Mr. Murphy also cited subsection 2, which states that unless the vehicle is ordered to be towed by a police agency or governmental agency, if the owner or other person legally entitled to possess a vehicle to be towed arrives at that location where the vehicle is located before the actual towing. And then Mr. Murphy went into what the police have to do in that situation. However, Your Honor, the first sentence of that subsection states, unless the vehicle is ordered to be towed by a police or governmental agency. The police in this matter, by that point, by the time anybody else had showed up, had ordered the vehicle to be towed. That's why the defendants were outside the vehicle and the situation had begun to escalate. So they clearly have statutory authority to tow the vehicle. Now, as it relates to the defendant's actions after they found out it was going to be towed, or any factual actions is a question more appropriately determined by a jury. The legal argument is that the police did not adhere to any type of written procedure. However, Your Honor, I did provide as Exhibit A to my response, the Adrian Police Department procedure, impound discretion at arrest, which states that the owner, or if the owner of a driver or driver of a vehicle is arrested and is not available to drive the vehicle away, the affected vehicle shall be impounded unless the owner or driver can immediately turn the keys over to a licensed driver. Now, Your Honor, again, I don't think the fact that Officer Allen with the Adrian Police Department originally stated that they could get a driver there quickly, and then later rescinded that is at issue today. We would stipulate to that. The defense has argued that throughout the pendency of this case. However, Your Honor, the case that the defense relies on, People versus DUI, specifically states that courts need not second guess a police officer's exercise of professional judgment regarding impoundment of an automobile when the judgment is exercised in accordance with otherwise reasonable police department regulations. Your Honor, the court has further clarified that and stated that courts should not, absent bad faith, render unconstitutional the decision to impound. There's no bad faith that can be shown in this case. So this court should not find that the impoundment of the vehicle was unconstitutional. We have officers who have a situation that is calm to start with, allowing a licensed driver to come get the vehicle. However, once Mr. Flores becomes agitated and begins displaying anger towards the officers at the fact that they would not tell him the information he wanted to know, now we have a situation where officers have to, I agree with Mr. Murphy, they have to try and de-escalate things. That's why they told the Floreses, you know what, if this is going to escalate, go home, we're going to impound the vehicle. They allowed Mr. Flores and Ms. Flores to get out of the vehicle. They told them several times to go home. That's shown repeatedly in the body camera footage. So, Your Honor, given the fact that the officers' policy states that they have to impound the vehicle, shows that they are operating within written procedures. There's no argument that these are unreasonable, that officers were not using their proper discretion when deciding to impound the vehicle. So I think based on the cases that the defense cites, this impoundment was constitutional. Just finally, Your Honor, I won't belabor these points anymore. Mr. Murphy also cited free speech arguments in his argument before the court. There's not been any law that's been cited up to this point that would provide the speech that Mr. Flores was using to be protected. I would ask that if the court does want to explore that First Amendment potential issue, that be briefed before the court making a decision on that. But anything as it relates to whether or not Mr. Flores was disorderly is a question of fact for the jury. So just in summation, Your Honor, the statute cited by the defense clearly provides the Adrian Police Department the ability and the legal authority to tow the vehicle. Their department policy and procedure is that unless there's somebody there immediately, they have to tow the vehicle. So that's what they were acting in accordance with. So, Your Honor, I would ask that the court deny the defense's motion in its entirety. Thank you.
So, Mr.
It's good. Good rebuttal. Someone said, "I hope the prosecutor has his act together." It sounds like he does. Let's see. Mary, Colin does. I don't know. I don't know the answer to that. It might be different in different jurisdictions. I don't know. How do you get arrested by Mr. Allen? I'll give you a real quick way to do it. Go show up in Judge Simpson's courtroom, hold out your phone, make it look like you're recording, so Mr. Allen has to be called over to you. That'll work every single time. Phil, thank you so much for the gifted membership. I appreciate it. Welcome to the new member. Thank you, Phil. And Mole. I don't think this is spoiling it. Judge Alsaver doesn't usually give immediate verdicts. Or immediate responses or rulings. Rulings is a better word. He doesn't give immediate rulings. He usually, takes his time and then mails out his ruling. So I think that's what he does. I don't exactly remember though. Then Mayor coming through with a gifted membership. Thank you so much, Mayor. Welcome to the new member. Thanks, Mayor. Appreciate it, buddy. All right. I think we're wrapping this one up. Let's go.
Bayonetto, can I ask you, when the initial statement was made that they would wait to allow someone else to come and take the car away, would that be in compliance or not in compliance with the city's policy about impounding vehicles?
The police officers do have discretion to allow that. It is located towards the end of the
Yeah, it's kind of the most entertaining part of it. Hearing the defense up there just running his mouth for 10 minutes. Yeah, if you want to, I mean, I would.
Policy that I provided, so they do have discretion to not tow a vehicle. But again, as the
Well, where is that? Because the paragraph I see says that deviation from this policy required approval of the shift supervisor.
Yes, Your Honor, and I can't say that they did contact the ship supervisor. I believe that was Sergeant Graff. I know he did show up on scene. I don't know at what point or if they contacted him. So I can't say for sure today whether or not they did or not contact him, but before that happened.
At what point, I don't recall, at what point did Officer Graff show up?
So if the court watched the whole body cam,
So I guess I should say, I'm sorry to interrupt, but I should say that I watched up until the point where the other people that came started walking away. It looked like, to me at least, the relevant portion of the interactions were completed.
I would agree with that. I don't know exactly when Sergeant Graff showed up. I do know it was, I believe they ended up putting Mr. Flores in Sergeant Graff's car. So I think it was right after the situation with Mr. Flores happened and as they were trying to get him in the vehicle.
I can go back and look again. I'm not trying to.
From my recollection, I believe that's when he
I'm
showed
not
up.
trying to hold anybody to anything. I just thought of someone absolutely new. So, okay, Mr. Murphy, do you care for any rebuttal?
Yes, if I could, I'll try to be brief, but I always lie when I say that. Hold on, I'm sorry, my computer locked me out. Your Honor, if I could refer back to my brief. I'm just going to quote what I put in the brief. It says the impoundment of motor vehicle is a seizure that must be scrutinized under the 4th Amendment of the United States Constitution, Article 1, Section 11 of the Michigan Constitution of 1963. And I cite People versus DUI. And I go into, again, in order for a seizure of a vehicle to pass constitutional scrutiny, there must be an established, and this is where I quoted DUI, an established set of procedures which the police must follow. I'm putting emphasis myself right on the must, but it wasn't in my text. Must follow in making the determination whether to impound the vehicle. The critical factor in determining whether too much discretion has been granted to the police officers regarding impoundment of an arrested person's automobile is the ability for arbitrary searches and seizures. Your Honor, that's why I cited, I have a concern with the statute or the Adrian City Police Department's policy. Again, they can't create policies that go against the Constitution. They can't create policies that go against
how does this go against, how does their policy go against the Constitution?
I'm referring to the discretion, Your Honor.
What discretion do they have?
Well, that's because
the policy. Where is the discretion?
In the Adrian City Police Department's policy, where it says that they can contact a shift supervisor. Deviation from this portion of the policy requires approval of the shift, and as Your Honor was discussing with the people, and I'm saying that section right there. That just opens the door for discretion that, again, in my opinion, would be against the idea that there should not be allowable discretion in the matter. They should be following these procedures.
But TUI allows for some discretion, right?
Well,
it doesn't say the policy can have no discretion. Yeah, no discretion. It's clear the law clearly gives the officers an ability to have some discretion in these matters, doesn't it?
Yes, Your Honor. But yes, I'm not saying that they can't have any. What I'm saying is this situation shows that there's too much discretion allowed. If this is a policy that was being followed, it allows for too much discretion in this matter because of what happened. That's what I was trying to say, Your Honor, that if the case was a situation they were following this policy, I think that policy allows for too much discretion because of exactly what happened here. But I would say actually they weren't following the policy because they didn't get prior approval by any shift supervisor. But I would say that's also the issue that we would have here, is it butts up against the idea of maybe too much discretion if all they have to do is get a supervisor to, after the fact, say, yeah, that was okay. And the reason for, again, why I'm bringing this up is I don't mean to hammer it too much, but I think the concern ultimately is, again, looping back to when people observe a police officer they believe is acting illegally at that time and place, the person can act, again, if they have an honest belief in that, they can act upon that and defend themselves. If the case is cited, they can defend themselves from that illegal police action right then and there. So the problem you have with a policy that may give too much discretion is that, again, what I believe happened in the situation. Now, if the police believe they're following their policy, that they could later get approval for the deviation of not immediately then and there towing the vehicle, then I would say that would be an example of why too much discretion could be a problem. But also, Your Honor, I wanted to point out that the statute again, as we all know, statutory interpretation and reading creation of the legislature, the statute, the language says, unless the vehicle is ordered to be towed by a police agency or a governmental agency designated by a police agency under subsection 1A, D, E, and K. There's no break, there's no comma, semicolon, anything. That statement is all encompassed. That means that unless it's towed by the police agency per those sections, it doesn't say by a police agency or then separated. It's by, because those police agency or government agencies will be the ones towing under those sections. So I don't believe that it's appropriate. Again, the burden's also on the people here. So if there is any type of I guess ambiguity in the statute, then I would say that the rule of lenity and the fact that they have the burden here would fall back on the defense. But I don't think there's any ambiguity in that statute. There's no break, there's no comma, there's no separation of the ideas of that sentence right there. Unless the vehicle is ordered to be towed by a police agency or governmental agency designated by a police agency under subsection 1A. Would you read that to say that, well, is the governmental agency designated by the section under 1A? No, you wouldn't read it to say that. So again, I'm arguing that this section says that as the people argued, they were towing under section G. If they were towing under section G, then when the owner had a legal licensed driver come, then it should have been turned over per that statute. Thank you, Your Honor.
Ms. Hennigan, do you care for any rebuttal?
Very quickly, Your Honor, Mr. Banner cited subsection G that the vehicle was hampering the use of private property. I just wanted to point out that this was late at night. The property owners were not even involved in this incident, and neither were they trying to move their vehicles at that time. That Ms. Flores did have someone come immediately, and so the car being there for a couple more minutes while those people arrived would not hamper the use of private property. Also, that this vehicle is owned by Ms. Torres, and so the prosecution has not indicated anything that Ms. Torres did that was a cause for the vehicle to be towed. So again, her behavior with regard to trying to stop them from illegally towing her vehicle was appropriate for her to ask for them to stop. Not saying that the manner in which her behavior was conducted was completely appropriate, but her request for the vehicle not to be illegally towed was appropriate. She should not pay the consequences for anyone else's behavior if, in fact, the officers felt that there was an issue with Mr. Flores' behavior. I also, though, concur with Mr. Flores' attorney that he also had a right to ask that the vehicle not be towed, and that was why he was emotional and upset. But whatever the case may be, Ms. Flores was not interfering with the officers doing their job. Thank you.
All right, so oral argument today has raised the issue of how MCL 257.25D interacts with the case law, and that was not briefed, so I wasn't particularly prepared to address those issues. I don't think I'm comfortable doing that now off the cuff. I would rather make sure that I give it a thorough reading rather than reading while I'm trying to listen and make sense of it all at the same time. So I'm going to take the motion under advisement and issue a written opinion, which we will get to both sides as quickly as we can once that's finished.
You want to have further briefing on the issue, or are you okay with what you said?
I don't think I need any further briefing on the matter right now. I think I just need to sit with it and read through it in light of the arguments that have been made. If I determine otherwise, I'll issue an order asking for.
Thank you, Your Honor.
Okay. Thank you.
All right. Yeah, I was right. I didn't think Judge Holtsaver usually made a ruling on the spot. And yeah, I think we all saw what direction that was headed in. I don't think the defense has a chance. Just my opinion. It could be wrong. If they do come back this week, I don't know if it'll be if they'll actually do another hearing on it or if it'll just be mailed out. But but I will make sure I have the follow-up if it does come back. Or if one of those two show up in court for their DUIs. I don't know. It just seems kind of confusing that they brought up the DUIs, but the 95% of that argument was about the towing. So let's just move on to the next case. Talking in circles. Let's go. This is Judge Webster. This is another DUI. And this guy had the opportunity of a lifetime to essentially get a DUI taken off his record, and he didn't do the basic stuff. Let's go.
Okay, Your Honor, we got Zachary Postovit. Postovit.
That's not how people usually pronounce it.
Yeah, I mean, it sounds like the defendants got the money they paid for out of the attorney. The attorney spent a lot of time on that case. You know, if it doesn't seem like it was a winning battle, though, but he tried. He gave it his best.
And Judge, that's a pro se case, so I'll probably just go off camera.
Well, it wasn't Postovit, was it?
I believe so, Judge.
Okay, thank you. Yes, Mr. Patterson. We'll be on the record now in 2023 TR 1829, State of Kansas versus Zachary Tyler Postovit. Jared Regier for the state. The defendant appears in person and pro se.
Shoot. I'm sorry.
Do you intend to have an attorney, sir?
No, I do not.
You've got driving under the influence of drugs, transporting an open container, violating an official traffic control device.
And Your Honor,
Mr. Regier?
make short work of things. This is a case where it does appear to come before the court on a motion to revoke diversion filed back in September.
And the allegations that he's violated include what, Mr. Regier?
Your Honor, the motion does appear to refer to two alleged violations. One, quote, that the defendant has failed to provide verification of successfully completing the DUI victim panel, and two, that the defendant has failed to provide verification of successfully completing level 1 treatment.
Mr. Postovit, you don't want an attorney, is that right?
Yes, Your Honor. I'm currently also taking the level 1 treatment, and I was able to provide proof of the other one. I got that into my diversion.
Well, let's slow down a bit. Okay, so you've waived your right to an attorney, is that correct?
Yes, ma'am.
You know you have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Do you understand that?
Yes, ma'am.
And knowing that, you still continue to waive your right and represent yourself today. Is that correct?
Yes, ma'am.
And on this allegation of diversion, I'm sorry, Mr. Regier, what did you say the allegations were?
Your Honor, the motion itself appears to list two alleged violations. One, that the defendant has failed to provide verification of successfully completing the DUI victim panel, and two, that the defendant has failed to provide verification of successfully completing level 1 treatment.
All right, now, Mr. Postovit, when this motion was filed, had you completed the DUI victim panel?
Yes, I did.
You already had it? You had it done before he filed the motion?
Yes, ma'am.
Had you provided him proof that you did it?
I was told that it was supposed to be sent in, but I guess it just didn't get to you guys, but I had it and I sent it in.
You didn't?
No, I didn't personally.
Did anyone else?
Yes, the people who where I got it done said that they were going to send it in so that you guys would have that.
He's saying that part is false. What about the other one? Did you complete your treatment before he filed this?
No, that was my mistake. I hadn't we were looking over the paperwork and we just looked over that bit and I hadn't gotten it quite done. So I'm in the class right now and I've already completed 4 class sessions.
Mr. Regier, do you have any evidence that he failed on providing proof that he completed the victim panel?
One moment, Your Honor.
Okay.
Your Honor, based off my notes, it would appear that at some point, the victim panel requirement was completed as set out in the diversion agreement. Originally, I am unable to determine at this juncture, based on a cursory review, to determine when exactly that took place. Nevertheless, the state would respectfully submit that it would appear that the defendant has admitted to the second violation, and from the state standpoint, that would be sufficient insofar as the motion to revoke diversion is concerned.
And the court agrees the defendant is found in violation for failing to complete his treatment within the time frame required and agreed upon, and in fact has still not completed it, but he's working on it. All right, so defendant is found in violation of his diversion, and the contract says if he's found in violation, the trial will be upon stipulated facts as stipulated to in the agreement. Mr. Regier, are you ready to proceed on those?
At the court's leisure, Your Honor.
Yeah, he done messed up. He did. I mean, I believe the charge is a DUI or equivalent to that. And for those of you that don't know what the diversion program is, you essentially have to do a couple things. You heard what he had to do. He had to take a victim class and he had to complete some sort of treatment. And I think the case gets dismissed. You have to jump through a couple hoops, and then they dismiss the case after the diversion ends. Yeah, it's a DUI, man. Do it. He didn't. He was lazy. Now you have to go to trial because the diversion. You also have to essentially admit guilt to enter the diversion. So he lost. He's not going to win this. I don't know what he was thinking.
Go ahead. If you would give me a synopsis of the stipulated facts in the agreement.
Yes, Your Honor.
It may not be dismissed. I don't know. Some diversion programs, they dismiss it if you complete everything you're supposed to. I don't know if it's dismissed or maybe it might be reduced. Generally, diversion programs go out to first-time offenders. That's generally how it works.
Pursuant to the agreement for pretrial diversion, specifically pages 3 through 4, it does appear to state that if criminal proceedings on the complaint are resumed for any reason, it refers to the a stipulation to the entire contents of the report submitted by Butler County Sheriff's Office in case 23-00006095. As well as count 1 of the information, as well and counts 2 and 3, which are for DUI, a Class B non-person misdemeanor, TOC, an unclassified misdemeanor, and failure to obey a traffic device, an infraction. Insofar as count 1 of the DUI is concerned, it does specifically allege that the defendant, quote, did operate or attempt to operate a motor vehicle while under the influence of alcohol to a degree that rendered the defendant incapable of safely driving a vehicle, or in the alternative, did operate a motor vehicle while under the influence of a combination of alcohol and any drug or drugs to a degree that rendered the defendant incapable of safely driving a vehicle.
And what was the alcohol he was transporting?
One moment, Your Honor.
Yeah, I don't know what's up with Judge Webster's subtitles. I feel like it's a different language than it used to be Spanish. I feel like I was on her channel the other day and it was French. I don't know. I don't know what they're doing.
Your Honor, if the court is prepared to accept a proffer from the affidavit in this matter.
Yes?
Your Honor, it would appear that pursuant to the same specifically paragraph 7, that the affiant officer did observe, specifically smell the odor of consumed alcoholic beverage. Further on, it would appear that standard field sobriety testing was conducted. However, the defendant did not consent to a preliminary breath test. Although the BAC does not appear to be in the charging language of the information itself, paragraph 12 does appear to refer to a BAC over the legal limit.
Well, what about these other charges, the TOC and the TOC and are you still pursuing those? Count 2 TOC, count 3 traffic control device. Are you still pursuing those?
One moment, Your Honor.
Yeah, Wixom. I had Debbie Davis on for the actual the hearing part of that. It was fun. Janie, good to see you, Janie. Thank you for the 9 months. That is awesome. Thanks, Janie. And Derval, very generous super chat. Thank you so much.
Yes, Your Honor. If this case were to proceed to trial,
I try to sneak it in during the quiet time. Sorry. Anyways, let me start that over. Duvall, thank you so much for the generous super chat. Oops, forgot to say hi and happy day after the other day. I appreciate it, Duvall. Thank you so much. Very generous of you.
And witnesses were called to testify. Besides the defendant having already stipulated to such a charge in the diversion agreement, the state's evidence would show that multiple open containers of alcoholic beverage were recovered from the defendant's vehicle.
And the traffic control device, what was behind that? He failed to stop at a stop sign or yield at a yield sign.
One moment, Your Honor.
Okay.
Your Honor, paragraph 6 of the affidavit does appear to multiple barricades across a roadway. It would also appear to suggest that 254 at the time of the alleged stop was under construction.
All right. I do find the defendant guilty upon the stipulated facts of counts 1, 2, and 3. And do we have an alcohol and drug evaluation where we can proceed with sentencing, Mr. Regier?
It would appear so, Your Honor. Based off of my information, it does appear to be a quite recent one.
All right, then, your recommendations for sentencing, Mr. Regier, we'll start with you.
Yes, Your Honor. For count 1, the DUI, the state is recommending the statutory minimum fine, which I believe is $750. Court costs, which I believe would be $108 in this particular instance. The state is also recommending a 6-month underlying sentence with a year of reporting probation and a $60 probation fee. That the defendant complete a DUI victim panel if he has not already done so, as well as comply with the requirements of the drug and alcohol evaluation. For count 2, the state is recommending a $200 fine. A 6-month underlying sentence. The state does not have an objection to that running concurrent to count 1 in a year of reporting probation with a $60 probation fee. And for count 3, that would appear to be charged as an infraction. The state is prepared to recommend the scheduled fine, which I believe is $75 in this matter. The state does not object to the defendant receiving credit for any payments already made in the current case, absent, of course, the diversion agreement fee.
So did I hear you correctly? Count one, you're recommending $750 in 6 months. Count two, $200. Were you recommending any jail sentence?
Yes, Your Honor. For that particular instance, the state is recommending 6 months as well, although the state does not object to that running concurrent.
And then count three is a $75 fine.
I believe so, Your Honor.
Mr. Post? Mr.
Yes.
Postman, do you have any recommendations or comments you want to make before I determine your sentence? You don't have to, but you're welcome to.
Was there any way I could get an extension on the diversion so I can get this class done?
Well, it doesn't sound like it because he had me proceed with the trial on stipulated facts, and I found you guilty.
About the $1,300 fine. No, I'm sorry. What was that again, ma'am?
We proceeded on stipulated facts and you were found guilty, so it's a little late to be asking that. I have found you guilty of DUI, transporting an open container, and violation of official traffic control device.
So what exactly was the traffic control device? The signs? For one, 254 was not closed down and under construction. It was only Butler Road, and it had a through traffic sign on it.
You
and I was through traffic because I lived on the other side.
Well, sir, you waived your counsel knowingly and voluntarily, both in the diversion agreement, again today orally. You stipulated to what the facts would be in the diversion agreement if you violated. We went into the trial. Mr. Regier proffered, and I took judicial notice of the diversion agreement, what the facts on the stipulation were. Based on the stipulated facts, I found you guilty. Now, I didn't hear him recommend your fines be doubled in a construction zone. I didn't hear that.
How could that not be? You were just talking about the what? Okay. And then the DUI victim panel, I don't know how you guys haven't gotten that in yet, to be honest, because I know I sent that in.
Okay, sir, we're just ready to proceed with your sentencing. I'll go ahead and do that. Your on count one DUI, your fine is $750. Your sentence is 6 months. On count two, transporting open containers of alcohol, your fine is $200 and your sentence is a concurrent 6 months. On count three, your fine is $75 for a total, well, let's see, I believe that you have a supervision fee of $60. And then you're going to have court costs of $108. I will give you credit for anything you, well, let me proceed. You are going to be awarded a 12-month non-reporting probation. You will get credit for any time you've already served against that 6-month underlying. Your probation includes all standard conditions, and probation will go over those.
And Your Honor, was that non-reporting probation or reporting probation?
It's reporting. I meant reporting.
Thank you, Your Honor.
No, Judge Webster asked, but instead of talking about sentencing, he started talking about the facts of the case. So when he was talking, he was responding to the question, do you have anything to say before sentencing? So he just missed his opportunity to say anything. He asked for an extension on his diversion class is what he asked for.
You will have to complete the DUI victim panel, which it sounds like you've already done. And if you just get proof to court services, you won't have to do it again. The drug and alcohol evaluation needs to be provided to court services, and you need to comply with it. Sounds like you're almost there, and just show them proof of that. You'll get credit for it when it's done.
Kathy, thank you so much for the PayPal. Very generous of you. Thank you. That is awesome.
Now, again, any payments you've made will be credited against the money owed, except the diversion fee. That doesn't apply towards fines and costs. Let's see, I think, you do need to pay 1/12 of the total due each month. You can pay more, but you have to pay at least 1/12. The first payment is due December 25th, 2024. And then on the 25th day of each month thereafter until paid in full. You can pay online, so even if the courthouse is closed for Christmas, you should still be able to pay online and meet the requirements. You also are ordered to go down the hall and report to court services as soon as this hearing is over. Anything else that we need to take up, Mr. Regier?
Not to my knowledge, Judge.
Oh wow, this is over. That went fast. I guess it has been an hour already. I was just just listening, reading chat, not even realizing there's only about 10 seconds left of this video. We need to raid somebody. Who are we gonna raid? Who are we going to raid? Let me set this up and then I'll properly say goodbye. Looks like Lone Wolf. Let's go. All right, we're gonna raid Lone Wolf. What was I gonna say? Yeah, I think Kathy for the PayPal. Is that you, Bertie? If it is, I'm sorry I used your first name. But it might be Bertie. But anyways, thank you. Thank you guys so much for hanging out with me tonight. It was a great night. 2 good cases. Told you they were good. Sometimes I'm worried when I have to go into the vault that the clips aren't going to be up to par. You know, if I pass on them the day it happens, I'm always worried if I go back, they're not going to be as good. But 2 good ones. Thank you guys so much for the super chats, the gifted memberships, the membership milestones, the PayPal. You guys are awesome. Let's go hang out with Lone Wolf. Make sure you tell him that I'm so much better at a streamer than he is. He loves hearing that. He really does. And I will see you guys. I won't see you guys tomorrow night. Tomorrow night's date night. So the next time I'll see you is on the 1st, start of the new month, Sunday night. Bengals play at 1, so I will be on Sunday night. And then members Monday on Monday. But I'll release some videos tomorrow. Maybe I'll do a premiere tomorrow afternoon. I don't know. I still have to put the video together of my trip to Judge Middleton's. Maybe that's what I'll work on tomorrow morning. All right. You guys are awesome. I'm talking in circles and rambling, so it's time for me to say goodnight. Let's go hang out with Lone Wolf. Until next time, bye.
Mr. Post-David, anything further?
No.
All right, thank you, sir. You're excused at this time. Go to probation, though.